Oyez, oyez, oyez. United States Court of Appeals for the 15th Circuit is now in session. Judges Tatch, Landry, and McDonald presiding. All persons having business before this court may draw near and they will be heard. Please be seated.
Number one on the docket is U.S. versus Rios. Appellants, you may begin.
Thank you, Your Honor. May it please the court. My name is James O'Keefe, arguing on behalf of the appellant defendant Aaron Rios. I'd like to reserve 1 minute for rebuttal. We ask this court overturn the district court's erroneous ruling in the motion denying motion to suppress evidence in violation of Aaron's Fourth Amendment rights. Not only did Aaron's girlfriend not have actual authority to consent on Aaron's behalf, the cops also didn't reasonably believe that she had authority to search. We would argue that this case comes down to the narrow dispositive issue of whether Aaron was physically present and expressly refused within the meaning of Georgia v. Randolph. The district court held a geographic litmus test in determining that Aaron was not physically present, even though he was inside of his own room at the time the officers approached the window asking for the search. Because the physical presence requirement hinges on whether or not Aaron expressly refused, we first start with the issue of express refusal. The police officers approached Aaron's bedroom window and asked over a period of a few minutes whether or not he would consent to the search. Aaron turned on his television defiantly in the face of the officers' requests. He sat on his bed while the officers continuously gestured. He shook his head and he approached the window and turned on the blinds right in front of the officers' faces. Accordingly, we think this is an express refusal. If this court were to hold that not an express refusal, then certainly how could a person who was deaf or mute or unable to speak expressly refuse to a search? Accordingly, in a case...
But, Counsel, isn't there a case that said you could actually blockade your house and against the police officers coming in, and that was considered not a refusal? In this case here, he didn't actually say, you can't come in my house, or you can't search my house, or you can't meet me. He just ignored him.
Yes, Your Honor, that was the case, U.S. versus McCarroll, but the distinction was in that case the defendant merely barricaded himself in the house and the officers had valid search warrants. In this case, there is no valid search warrant, and the entire point of the officers trying to get access to the house is to ask the defendant inside for consent. In that case, the defendant was merely barricading himself. In this case, the defendant is turning down the blinds on the officers while they're asking him continuously for consent. And again, if this court were not to hold that continuous gestures constitute express refusal, then how could someone who couldn't talk ever expressly refuse?
They could actually write something on a piece of paper and go, no, couldn't they?
They possibly could, but again, we would argue this court should draw from all of these gestures. Shaking of the head would be sufficient, would be comparable to writing something down on a piece of paper. Because the physical presence requirement hinges on express refusal, so we now turn to physical presence. The defendant was physically present within his own bedroom at the time of the search, at the time of the consent rather. When the girlfriend consented to the officers, we are uncertain where the defendant was. Time estimates and the facts indicate that approximately 13 to 15 minutes have passed when the officers went around to the front of the house. We aren't certain. The defendant could have been in his bedroom, he could have been in the hallway, he could have been at the doorway. We are not certain where the defendant was. However...
But again, that gets back to your coulda, woulda, shoulda. Because the fact that he exited the premises prior to the cops going in, obviously he was not there, so we know that much. We don't know whether he left 1 minute before the police went in or 30 minutes before the police went in. Does his leaving now subject him to the possibility that his girlfriend's going to give authority? Now, you said that she didn't have actual authority, and I saw nothing in the record that said she didn't have actual authority. I would think the fact you have a key, groceries, and coming to a place, if that's apparent authority, rises to such high a level that she obviously had a right to go on the premises. So when he leaves, doesn't he give up that protection that his co-tenant or somebody else is going to let the police officer in?
Well, Your Honor, actual and apparent authority are irrelevant in determining whether or not the defendant was physically present and expressly refused within the meaning of Georgia v. Randolph. That's a separate exception. That's a separate rule. There's two different ways this court could look to overturn the district court's decision. Whether or not the girlfriend had actual apparent authority is a separate issue than whether or not the defendant expressly refused and was physically present within the meaning of Georgia v. Randolph. However, according to U.S. v. Murphy, the defendant doesn't have to be physically present within his own bedroom for his consent to overturn the consent of his girlfriend when he previously consented in the area to be searched.
Yeah, my question was, once he left, doesn't that change the circumstances?
No, it doesn't. It doesn't change the circumstances, Your Honor, because when a defendant expressly objects to the officers in the place to be searched, and the officers then subsequently immediately try to obtain consent from the third party, that doesn't override the consent.
Okay, well, how would you define immediate? 1 minute, 35 minutes, the following day, the following week? I mean, is his refusal good forever?
Well, the court in U.S. versus Murphy held that after 2 hours, it didn't overturn the consent of the defendant. In this case, we have 13 to 15 minutes at the same property, whereas in Murphy, it was storage units, and the landlord resided on the other area of the property in a different unit. So accordingly, according to the case in U.S. versus Murphy, Ninth Circuit case in 2008, the consenter, the defendant in this case, his express refusal should override the third party's consent on his behalf. Now we move on to the issue of actual and apparent authority. This is a separate way we can suppress the evidence obtained. Janice Parker was a 19-year-old girlfriend of Aaron's. She was staying over the property once or twice a week. According to the U.S. Supreme Court in Matlock, the third party must have either joint access or mutual use for most purposes. Here, Janice Parker did not have that actual authority. She only stayed at the property once or twice a week.
Okay,
But
question.
counsel-
Okay, good.
Counsel, didn't she have a key, and didn't she bring in groceries, which would assume that she's maybe cooking at the house?
Yes, Your Honor, she had both of those. According to a federal district court, U.S. versus Reed decided that mere access is insufficient. Those two factors are factors to consider, but they're not sufficient in determining that she had actual authority. The key merely implied her access to the apartment. According to U.S. versus Koss, another a 10th Circuit decision in 2007 decided that when a girlfriend's children were in the apartment and the officers saw those children, that would not be enough to imply that the officers reasonably believed that the girlfriend had both mutual access and joint control for both purposes.
Okay, how about the fact that she comes to the premises with the groceries, et cetera, and they're investigating an alleged crime? Should they have just ignored the fact she's an unarmed woman going into the premises and let her just go in without them doing anything?
Well, they probably shouldn't ignore her going into the premises, but she had a key to the apartment, so there was no evidence that she was going to commit a crime.
No, we're not talking about her committing a crime. You've got a guy who may have been, the police were wondering whether this guy just broke into the subject property. They didn't know who Mr. Rios was at the time. So there may have been a person in there that it wasn't belonging in there, so their argument would be that they're protecting her, right?
Well, the officers admitted in the police record that they did not believe that the defendant, Aaron Rios, posed any threat whatsoever. And it was only after that admission that they then used that as an exception to the idea that they did.
True, but that was when they were looking in the window. They decided they didn't pose a threat to the police officers. My question is, would there be exception that they may have thought the threat to the girlfriend?
No, the officers didn't reasonably believe they had any threat to the girlfriend because the girlfriend didn't. I see my time has passed. May I conclude?
Yes, you may.
We again ask this court to overturn the district court's erroneous ruling, denying motion to express evidence, both on the grounds they held geographic fitness test under Randolph and the girlfriend did not have actual apparent authority. Thank you.
Thank you.
I'd like to rebut. I have 2 points for rebuttal. Your Honors, Justice Breyer expressed concern in Illinois versus Rodriguez that, for example, there might be some type of spousal abuse situation when girlfriend consents on behalf of a suspect inside the house. However, the constitutional Fourth Amendment is paramount. And although there may be some type of speculation that there is some danger to the girlfriend, the officers cannot just manufacture a situation based merely on speculation that there is some type of danger to her. There's no constitutional recognition of this. Secondly, in regards to the express refusal issue, the officers used the word refusal when referring to what they had just witnessed based on the gestures of Aaron Rios. Secondly, according to the dissenting opinion in U.S. versus Hudspeth, the judge used the language, said that we should not base the Fourth Amendment based on a tape measure, how far away you are from the door. So for these reasons, we again ask this court to overturn the district court's decision. Thank you.